A lot of different ways. And the other issue is whether states that do not permit same-sex marriages have to recognize marriages performed in other states. That's another element to this, obviously on a federal level.
I think that one it's more likely to get a majority. But on the fundamental one of is gay marriage a right, I think it all hinges on Kennedy, on what side of the debate he gets out of. Remember, he wrote the deciding opinion in the decisions in 2013, overturning the Defense of Marriage Act, meaning that the federal government had to recognize a gay marriage in any state. And he offered two defenses of his position, and they were somewhat contradictory. One was federalism, state rights. Marriage is under the authority of states, so whatever a state decides, Washington has to recognize. The other, however, was equal protection, which implied that every gay marriage ought to be as equally protected, or that institution should enjoy heterosexual marriage rights. If you say that, then you imply that denying a gay marriage is invidious discrimination. It's a form of animus. He doesn't resolve that, but everything in the opinions he offered 2 years ago indicates that he was ready to go all the way and declare it protected by equal protection, in which case he would overturn all the state laws.
There's one more thing. If states license ministers to conduct marriages, would those ministers, if it is constitutional, then be required to conduct same-sex marriages?
Right, and then you go to the religious liberty argument. I mean, this is one area where I think conservatives are shifting their focus now, in a sense, almost conceding that the gay marriage debate, for all intents and purposes, in the political realm is over. But can they sort of protect those religious liberties that, certainly I would argue that the founders intended?